employers and organisations will at some stage receive a grievance from their employees. Now, that grievance may be well-founded or it may not, but there are important obligations or duties or things that the employer will need to do to deal with that and address it. In the first instance, it will be important to understand the detail of the grievance that they've received. So that might require an initial meeting with the employee to understand everything that they're complaining about, but also how they want it to be resolved. And from there, you can agree a timetable with the employee about what will happen next, how much investigation is required, whether any suspension or any other action is immediately necessary. The employee will want reassurance that their complaint will be treated seriously and confidentially, and then from there, the employer will need to look at what the appropriate next steps are. Now, once a grievance hearing is held to look at the complaint and make a decision, the outcome of that may be that there are further consequences, perhaps for another colleague or something else within the organisation, or it might be that the grievance isn't upheld and the employee concerned is disappointed by that. So the final stage in the process is making sure that the employee knows they have a right to appeal against the decision that has been made. Of course, if the employee remains unhappy about the outcome of the grievance or their situation at work, their next stage may be to raise a complaint through ACAS and file a claim with the Employment Tribunal. ACAS is the Government Advisory and Conciliation Service. They are the first point of call because they're there to try and resolve the complaint between the employer and employee and see if a dispute can be settled without the need to go to the tribunal. If it can't be, then the employee must present their claim within 3 months of the incident they're complaining about, and they will do so on a specified form, ET1. Once that's received, a copy will go to the employer, and the employer will have 28 days to file a response to it. From there, the tribunal will set a date for the full hearing, and they will set out a number of steps to prepare for that, which will involve the exchange of documents and the preparation of witness statements.